Good afternoon, everyone, and welcome to Fridays with Keenan's Cutting Edge. My name is Jenna Labor, and I will be your host as we explore the dynamic world of Don Keenan's trial philosophy, The Cutting Edge. Those of you joining us live this afternoon have the opportunity to ask questions and interact with our speaker. If you have questions, please enter them into the comment section below. That way we can read them and really get into good discussion. Episodes are released each week following the live broadcast, so be sure to hit that subscribe button and click the alerts icon so you don't miss an episode. Today, we have Matt Lathrop with us to talk about the Undergraduate Voir Dire College. Matt practices personal injury law in Nebraska, as well as being KTI faculty. As always, we'll put his contact information in the description below so that you can contact him with any questions about this college or anything Edge. Matt, talk to us about the Voir Dire College and what we can expect when we attend.
Well, let's start with thank yous. Thank you, Jenna, for inviting me to speak. It really is great to be a part of this podcast. I was telling you, I listen every Tuesday. I download last week's episode, get on the treadmill in the morning and listen to it. It's just great. You have great guests that do a great job of kind of jazzing me up each week for the Edge. And it's really kind of humbling to be here. So thanks for asking me.
You're welcome.
So I am one of the faculty. I'm not the dean or co-dean of the Undergraduate Voir Dire College, but I have been teaching it for, it's got to be 3 or 4 years now. I've been teaching since before COVID for sure. And I start every Voir Dire College with this question for the participants who show up. I ask, how do you feel about Voir Dire? So, I mean, just start with that question to get everybody in the right frame of mind. And Jenna, maybe you've taken the Voir Dire class or the college, but the first time I sat in the Voir Dire College as a student and somebody asked me that, my answer was, I am bad at it. I don't like it. I ask a lot of close-ended questions. And I didn't have any purpose. There was no end game involved in my voir dire of a panel. It was really find and strike was my philosophy. I want to strike people who I think are going to be bad jurors. That was me going in. And if I had to rate myself, that's the other thing I do is I say, you know, as a lawyer right now, rate the last voir dire that you did. Tell me about your last jury selection on a scale of 1 to 10, with 1 being, I just got out of law school, I've never done a voir dire, and 10 being, you know, I'm ready for the inner circle. How would you rate yourself? And I mean, I would never give myself more than a 4 for my jury selection, mainly because if the question was then asked, what were you trying to accomplish in jury selection? I'd say, I don't know. I really don't know. I was trying to get it over with without looking stupid and get to my opening statement, which I had practiced a lot. And so that's how I start a class with people. Because I think a lot of us come in understanding how important jury selection is, but not knowing how to properly use, I think, one of the most important tools that the system gives us. I think the civil procedure gives us the right to question a panel of jurors to have the best possible jury for our case, and we get the first crack at them. As plaintiff's lawyers. So that's just kind of how I started. And then I tell the people in the class, what we're going to do is learn how we win our case during jury selection. During jury selection based on our suit, based on how pretty our client is, or how handsome he is, or how neat the desk is that we're sitting at. We win our case because we go in with a purpose and we are intentional with every word we use during jury selection. And so what is the class? The class takes that's the first half hour of the class. And the next day and 7 hours is learning how to use that jury selection process the right way to win our case.
All right, that's fantastic. What do you do, Matt, if you get somebody in your class who either does not have attorney-led voir dire or has really short voir dire? For example, in Washington, we get a good 20 to 30 minutes.
It's a great question. And there is a section of the undergraduate class where we talk about that. The graduate class, I don't teach it, but I've taken it. Really, really a great class. And we can talk about that later if you'd like. But we have to know, we have to be prepared. Every lawyer does for the short jury selection process and the longer jury selection process. I have had it where a judge told me, you got 30 minutes. And the answer to the question or the riddle that you're asking, Jenna, is we try to teach you how to do a full jury selection. We then teach why each section is important of the jury selection and how they tie together. And then once we know all of those things, in a course, in a 2-day course, you aren't going to go from not knowing jury selection to being inner circle, but you're going to know why you're doing what you're doing. And then with 30 minutes, you can say, all right, I got to take all of this stuff that I want to accomplish and get it into 30 minutes. And there is a strategy for doing that, where we might take 20 minutes during jury selection to do part of what we're trying to accomplish. We know we only have a few minutes, but if we know why we're doing it, we can do that. And during the rest of the jury selection, we'll get opportunities to build on that. And so once we know why we're doing the whole long enchilada, then we can say, well, I only get 30 minutes and I know I got to do this part, and I'll sprinkle the rest of it in there.
Okay. All right. What, if I'm going to take this course, what do I need to bring? What do I have to have prepared?
We ask that you do a case summary for the undergraduate voir dire class. And we also assign we assign many blog articles for you to read ahead of time. The reason we want you to have that case summary is because, again, I'm going to go back to what I used to do before I took the college course. I used to have the same jury selection if I was doing a supermarket slip and fall or a car wreck or, medical malpractice. It was the same outline and I'd get the same results. Now I know when I learn this system we have for jury selection, our case facts, knowing our case facts is critical to an effective jury selection. Nebraska's law, probably just like your law, is we can't talk about the facts of our case. We can't tell a jury, you will hear that this is what happened. But during jury selection, if we don't know, or if we aren't thinking about our case, we're missing the opportunity to find out what is a juror's attitudes or expectations about what a supermarket ought to be doing or what a driver on our roads ought to be doing. And those are issues that are going to come up in our case without talking about the facts of the case. And boy, when you get into the groove during jury selection, the jury not only understands your case, they've figured it out and they've decided your case because you're just asking them about expectations. So what we ask you to do is bring in that case summary so you know what your case is about and read those blog articles, because those blog articles, every time I teach the class, I go back and read them and I pull something new out of them, and they're just, they are gold mines for a lawyer who wants to get better at jury selection.
All right. What I expect to get out of it? What skills or materials will I get from the undergraduate voir dire college?
So now some people listening may say, I don't want you telling me exactly what to say or how to say it. I'm my own lawyer. Other people would say, please give me some kind of a template or a system I can use that's going to be effective. What we provide you, and it's our suggestion that you use it and follow it, what we provide you is a very structured template for how to go through jury selection. And when I teach the course, I teach not only, all right, we're going to talk about this topic, but here's why we're going to talk about it. And here's why we do it at this particular point during jury selection, because you don't want to get out over your ski tips during jury selection. You have to build and develop this jury panel into a group that's receptive to my case and my issues. And so we walk through from the very first thing you're going to say to this jury panel to the very last thing you're going to say to the jury panel. And yes, we do give you a template with the language that has been tested and we know is effective. But, I can't, this guy, and by the way, I could not get anything more white if I tried, unless I bleached my teeth. Sorry about that, I wasn't thinking. But this guy from Omaha, Nebraska could not do a Papa Don jury selection. And we don't get into the college and say, here is what Papa Don does, and you will be Papa Don when you do this. What we do is we peek behind the curtain. And we hear a lot about, well, that college taught me a little secret sauce, or there was that one half hour where we had some secret sauce on that topic on cross-exam or on trials. This is 2 days of secret sauce. This is everything we do in that college is secret sauce, and it is career changing, I think. I used to, as I said, I went from not liking jury selection and just trying to get through it, not stumble over it. And I was a little, I got a personality, do a little jokey joke, maybe make them like me, tell them about my kids, a couple of funny anecdotes about how my wife treats me, right? Those kind of lawyer things. And I thought I was doing well. And it was not effective at all. That was my jury selection. And now my jury selection is completely different, and it is every minute of it is intentional. And if a judge tells me how much time I have for my jury selection, I say I can do it in that amount of time. If you tell me I have 45 minutes, Judge, I will be done in 44 and a half minutes. And I am. And it's not because I'm staring at my watch. It's because I know what I'm doing. I know how long things take. And I have to tell a little story here. I had a trial last November where the judge told us we could have 45 minutes. And it was a federal trial. And she said, that's all I ever give, 45 minutes. And we filed a motion. I had a trial to ask for additional time. And we asked for an additional 30 minutes. So I was hoping to get an hour 15. She said, well, I'll meet you halfway and I'll give you 15 minutes. And she wagged her finger at me and she said, be careful what you wish for. I've watched a lot of jury selections, and these lawyers just bore these jurors and they lose them at the beginning of the trial and they never make up the ground. And she said that to me. And I did my 1 hour jury selection in that case. And first of all, it was one of my best jury selections. It just went really well. And more importantly, the judge loved every minute of it because it was so engaging for her to see the jurors get into and participate in jury selection. And this was kind of during federal court COVID restrictions where we had people spread out all over the courtroom, and they had a microphone set up like it was a spelling bee. And they were going to have the jurors get up. If I said, oh, Jenna, you raised your hand, now stand up, walk up to the microphone, and we're going to quiz you. I saw that going on, and I said, well, do we have a handheld mic or something for the people in back so they don't have to get up? And that turned into the football during jury selection. We had, okay, Jenna, thanks. Looks like Tony over here had something. Jenna, could you hand it to Tony? And Jenna got up and handed it to Tony, and the jury was, they were interacting with each other, and it was, my worst fears were avoided thanks to a handheld microphone. But thinking on your feet, knowing why that was important was instrumental in bonding that jury like I did.
Mm-hmm. Yeah, that's one of the biggest takeaways I had from the Undergraduate Voir Dire College way back when I took it was, why do you do jury selection, right? I think without this course, you think it's to find the good jurors for my case, which that's logical, certainly is logical, but there's a lot more to jury selection and that process than just finding who's going to be good for your case, or conversely finding who's bad for your case and getting rid of them. So that, talk a little bit more about that. I know there's some secret sauce element to it, but what is some of the purpose of voir dire that you can't talk about?
Well, so we know, by the way, you said, how do the jury selection so I can find and get rid of those bad jurors. I don't know what a bad juror for my case is from jury selection. I know what a bad juror is from my case because of focus groups, right?
That was my follow-up question. How do focus groups tie into all this? Exactly.
Yeah, and that's the other class I teach. So I really benefit a lot from those two courses. Focus groups are where I learn what a bad juror is. Mm-hmm. I was doing a focus group for one of my cases coming up, and I always do, this is another little tidbit, I always do at least an hour of jury selection in every focus group. My first hour is some part of upcoming trial jury selection. I'm testing out language I'm using, I'm testing out ideas and issues and attitudes. But during that jury selection process in focus groups, I learn who those bad jurors are. So I was doing a focus group a couple of weeks ago, and I had somebody, in my case was a car wreck case. This participant, as it turned out, by the way, this participant was the brother or the nephew of a lady I represented. So I represented a lady in a wheelchair, got hit by a car. I had that case. And this guy was on my jury panel. I would think, well, this guy's going to be awesome. He's got an aunt who was hit by a car, not her fault. He's going to be an awesome juror. And I would have assumed that he was the worst person I've ever had on a jury. He literally was 100% defense on every case that we talked about. He would have given his aunt nothing in my trial on her case. So what did I learn about that? What I learned was the guy looks great on paper, or, his name, and he's got an aunt with it. I did the whole, anybody been in a car wreck? And he was right there on all those issues. But through focus groups, I learned more about his background and his attitudes that then I use in the next jury selection, and I find him. And so your question was, what do we do when we find those, or what's the purpose of jury selection? It's to recognize things we heard during our focus groups that are telling us this is a good juror, or this is a bad juror. And when we find those bad jurors, what do we got to do to get them to disqualify themselves? Because there is no amount of pushing on that donkey that's going to get them to stop or say they should be off the jury. What's going to get them to say it is to convince them, or give them the opportunity to convince themselves, I'm a bad juror for this case. And once they've said that, there's, a judge, and we have, Papa Don talks about the stick of dynamite up the ass rehabilitation. That's the law in Nebraska is if we stick a dynamite up your ass and light it, will you follow the law? Yeah, I'll follow it. They will do that. But our goal and what we learn about in this college is one of our purposes, and I ask all of my students in the class, what is the exact language that a juror has to puke out during jury selection that the case law says that's the fatal blow? And so I have my notebook and I know what Nebraska's case law is. And I know I'm not looking, I won't look down at my notes. A juror in Nebraska has to say he or she will not subordinate their personal and strongly held beliefs to the law in a case. So I just get them to go down that road of how strongly held that belief is, and they aren't a person with wishy-washy ideas. They're a person of convictions, and they couldn't take a firmly held conviction like that and make it and say that I'm going to abandon that because the law is different from what I believe. So you would not be able to abandon your personally strongly held belief if the law was something different. No, I would not. And that's I won't subordinate my thoughts or my beliefs to the law. So yeah, without getting into secret sauce, the purpose of voir dire, generally speaking, we want to make jury selection about jurors. We don't want to make it about Matt Lathrop. That is for sure, because the jury doesn't care about Matt Lathrop. And even more importantly, and even less, they care about my client. And they won't care about my client. And so I want to avoid that topic with as much care as I can. And so how do we do that and still get the jury to talk about things like damages, things like the burden of proof, and things like what are my expectations for drivers of 18-wheelers out there on the road? Okay. Getting them to talk about themselves starts the process of finding out what their real beliefs are. And we may have a case where there's bias or prejudice that is sitting right there in the courtroom. And if I have a client who is traditionally the subject of bias or prejudice, we teach in the college, how do I deal with that? How do I get the jurors to talk about and to admit that they have these prejudices? And the secret is they're never going to tell you, yes, I'm a prejudiced juror. So we got to figure out how are we going to get them to tell us about these beliefs without getting them to admit that they have them. And that is, it's important because it's not just, racial bias. There are bias. Some people just have bias against women. Some people have bias against overweight people. And we break those things down and we say, well, how are we going to deal with that? And how are we going to get these people to talk about it so we can explore the issue? And it isn't the Paul Newman, my client is a minority, what do you guys think? Because that isn't going to work. That isn't going to work.
Right. That makes sense. And you figure out what those issues are, again, through focus groups, right? Like, what are the issues with your case, with your client, with your facts, whatever it may be, so that you then can take that information and put it into practice in voir dire.
Exactly. Yep. And so let's say if I do 3 focus groups on a case and I keep getting that same guy, he keeps, not literally him, but that same personality type keeps showing up. As an example, the case I just tried was a rear end collision case. And there was a lot of facts before the rear end collision that made it, which is why we tried it. But here is what one of my focus group participants said that absolutely put a pin in what my problem was in the case. And it was this horrible juror said, look, I can follow that guy in front of me bumper to bumper 1,000 miles, and we don't ever have a wreck unless he hits his brakes. Okay, so my case was my guy kind of brake checked him, and when he did that, there was a rear end collision. And so that was my really bad juror, and that same attitude kept popping up, but he was the only one who put it in those terms. And so during jury selection, now I know how these jurors are thinking, and I can ask, does anybody lean this way? Do you feel like rear end collisions don't happen? I mean, you could drive 1,000 miles bumper to bumper behind somebody on the interstate, and there's no collision as long as the car in front of you doesn't hit his brakes. Who feels that way? And I had 3 of them on my jury, right? And it was the question that came out of the focus group, and I was able to work it into my jury selection. I knew when I wanted to ask it, because you don't just start with that question, right? Because jurors, I think the first thing that happens when a juror's sitting in that box and they're staring at a lawyer is, this man or this woman is about to ask me really personal questions that are really embarrassing, and it's going to be about either my criminal history or dumb things I did in college, and I'm terrified of what this person's going to ask me, and then the judge is going to make me admit it right out there in the open. So I think that's what jurors think when when we walk up to them and we're going to start jury selection, and we're the very first person they see. So the last thing we want to do is ask a question that's going to make them uncomfortable. We want to start with questions that they're going to be comfortable with, to see this Lathrop guy isn't such a bad guy. He's okay. And if I were to ask that 1,000 miles bumper to bumper question at the very beginning of my jury selection, I think what they would say is, this is a trick question. I know what the right answer is supposed to be, so I'm going to give them the right answer. I'm not going to give them the true answer, because there's something about this process where they're trying to get me arrested for tailgating, right? So knowing what those issues are and how those bad jurors are going to react on your panel and what you're listening for, that's kind of part of the process that we learn too.
Okay. I don't know if other people think about this, but I do, because we have a county with very, very difficult jurors notoriously, and it's one that I just tried a case in. And what do you do when all you have in your veneer are bad jurors, and they all hate car crashes, and they all hate plaintiffs, and they don't believe in awarding money for pain and suffering? And I mean, you see this panel and you go, I might as well give up now. I mean, what do you do? You
give up, Jenna, and you come to Nebraska where all the jurors are flaming liberals and hand out money.
Those are that's the bad ones in Washington. The liberals are most it's the worst place to try cases, because they believe in forgiving everybody. They don't believe in accountability for violating the law. I mean, Seattle has removed all law in its entirety. You can't get in trouble for anything. So there is no accountability. You can't get them with anything, and it's frustrating. And they're all tech people, so they don't have a heart, barely have a soul.
Right. Right. So you're looking at, we start with 21 potential jurors to get to 12 plus an alternate. That's what we start with. And that's what that's what I look at when I look out at these people, and I look at their careers, and I look at their, we have 3 or 4 huge insurance companies in Omaha. And so you can't pick a jury without 4 or 5 people on the veneer who are in the insurance industry. That's, and none of those people like lawyers. So, but that's what we look at. So what do I try to do? Worst case scenario, I'll tell you what I'm looking for: characteristics of a leader. If all I can do is I'm going to have 12 bad jurors, let's say, is there one in there who might be good for my client that's a leader? And what do I got to do to make sure that person's on the jury? and who are those other leaders that are bad for me, and find those leaders and get them off no matter what. And I'll say this, the last jury selection that I did, my trial a week ago, there were two people on that jury that we did not like. I had spotters, and all of us agreed these two people are terrible. And we recognized that during jury selection. And I asked questions of those bad jurors that really made them sound plaintiff friendly. And lo and behold, defendant strike one and defendant strike two were the bad jurors that I needed to get rid of, because I got a little bit of something from one who had a family member who was in a car wreck. And juror number two was talking about how pre-existing injuries should not be a bar to additional recovery. Okay. I know that I've tested those in focus groups. Those are very vanilla kind of topics that you can get a juror to agree to, but a defense lawyer whose case is built on pumping up the pre-existing conditions, they want to get rid of that person. And so I knew that I wanted to get rid of them because of answers they'd given to other questions. So I circled back around and kind of hung the scarlet letter on them. So at least I got rid of those two. And the leader that we did have, we knew was going to be the foreman. It was pretty obvious. To us, he seemed like a pretty thoughtful, reasonable person. So we were comfortable with the jury, because there were those two bad jurors, and then there was a real bad juror who was going to be, probably would have been the four person. That was our first strike. And the lawyer after trial said, "Why did you get rid of so-and-so? She seemed like she was pretty neutral." I said, we were kind of just staring at the sheet and we didn't know what to do. But I wanted to get rid of her numero uno. So maybe, when you have 12 bad jurors, you're looking for the one who will be the leader back there, because leaders get a lot of things. They have a way of putting their will on other jurors who just want to go home. I want to get my free pizza and get home before 5. Yeah.
Yeah, no, that's an excellent point. And it's number one, being able to use the defense in your case, right? That's so excellent. And then also knowing how to spot leaders. And I remember talking about that. I had never thought about that before. Granted, I think I had only tried one case by the time I started doing Edge, but I had never been told, hey, look for these personality traits in certain jurors. And I really have, the more I've tried cases, the more I see that come out. You could have a juror who is 100% for you, but if they have no backbone and they are drowned out by another person, that really isn't a good juror for you. It's wasting a place.
It is, and it becomes the person, like I did, it becomes a person, this person is going to go wherever this case goes. Let's pump them up and make the defense lawyer have to use a strike on her, exactly. Right? Or if we find somebody who's really going to be, that scares us on the defense side, let's draw attention to them, unfavorable attention to them, put a big target on them for the defense. So yeah, and it's something we teach in the college, the characteristics of a leader, and the characteristics of a juror who just generally is going to be someone that's back in that deliberation room is going to be good for us.
Absolutely. Yeah, we were able, actually, it was kind of a surprise to me in this last trial. I was able to inadvertently get defense to strike somebody that I wanted to strike. Ended up being a lawyer, and she practiced immigration law. And she had on her website, she's a solo, on her website, all of these things about just being very compassionate towards homeless people, compassionate towards immigrants, compassionate, all these things. But there were some answers she gave to some questions where I was like, ooh, can I rely on that compassion that she projects, right? It's hard to know whether someone really is compassionate or whether they project that for various purposes. And we came down to the fact we would use a peremp on her. If we couldn't get her to get herself out, we would use a peremp. And defense counsel for the same reasons that we thought that she might possibly be good for us, he got rid of her. And I was like, thank you for just taking that off our plate, because I think she would have been terrible for us.
Do you get in Washington, I know limited voir dire, but do you get jury questionnaires so you get some background?
We do. The court puts together a juror questionnaire. We used to never be able to submit questions. Now during COVID, I don't know, they've allowed us to. So we had a couple of issues that we did put on our judges' jury selection questionnaire.
And do you get that ahead of time?
Yes. Well, now we do. We used to not.
Right. And we don't. Here's what we get. We sit down, the jury veneer comes in and they hand us the list of jurors.
Yeah.
And it's their name and their address. And that's all we ever get. And I did that November trial over in Iowa in federal court, and we got a 6-page, 7-page questionnaires, and they gave it to us a week ahead of time. We had our jury picked, and we ranked everybody. We knew exactly what we wanted, and that made jury selection a whole lot easier. If you
that was never the case here until we started doing things I guess I should say the trial we just had was the only trial I've ever had that in. I was so pleased because we had a week, I think it was a week before jury selection. We knew who the veneer was going to be composed of. We could do background research. We are a small firm, so there are some bigger firms who during voir dire, they can have somebody back in, at ground zero doing the research and like piping information to you. We never were able to do that. And
that's just bull. That's on the TV show bull. They have it, and nobody else does, right?
I know 2 firms that have the resources to do that here, and I'm always so jealous. But but that kind of if anybody out there who's listening to this, if you have the opportunity to do it ahead of time, if you have the opportunity to use what you're learning about your voir dire and do a quick focus group on it, I mean, that's perfect world, right? I know the time between when you get that and trial is usually filled with a lot of stuff and things that are going on, motions and whatnot. But if you can really test that, or at least put it against what you've got, that's great. If you're in a situation like many people are, where you get the sheets of paper, you've got 15 minutes to review it, and bam, well, hopefully you've done all the work ahead of time by going to this college, really narrowing down your issues, and knowing at the very least who you don't want on that veneer.
Yeah. And it is not part of what we teach in the course, but I tell every class that I teach, I do a 2-hour jury selection or voir dire the night before. I get a focus group, and we get together, and it's usually about 5 to 7 p.m. the night before trial, and I do my voir dire, and I have 10 or 11 focus group participants, and I'll do it, and whatever my time limit is from the judge, I do it. And I'll tell you what, not having a time limit is almost a curse, because we have a lot of judges in Omaha that let us try, like this last one I did, take whatever you want. I mean, it's a 3-day trial, but if I want to do all day voir dire, he's going to let me. That's a curse though, because you're saying, I can do this, I can do these questions all day long, and you really shouldn't. But I like to know I have my jury selection solid, and I did it the Sunday night. We picked the jury Monday morning, and I asked a question during my jury selection that I thought was really good, and it was a grenade. It just went off, and it was horrible. And I'm so glad I did that jury selection the night before, because I did not ask that question or get anywhere close to it during my actual voir dire, and I'm glad, because it would have been horrible. Yeah. So I can't speak strongly enough about how great a voir dire the night before. And the first time I did it, I thought, the night before, for crying out loud, I got a million things going through my head, and I'm not even going to sleep tonight, much less do a jury selection. I have the best night's sleep ever the night before trial when I've done a mock jury selection, because it gets all the butterflies out. You know exactly what's going to happen when you step up there the next day in front of the judge, and And yeah, it's so that's the what are the guys down in Louisiana call it? The lagniappe, right? The extra little free something. Yeah. When you order something, they always put a lagniappe on your order. They give you I didn't know I asked for a beignet, but they gave it to me anyway. So,
Oh, I never heard of that in my life. That's so cool. I have a new word.
Yeah, work it in.
Nice.
Let's see, what else was there? So yeah, the emphasis that I make not only on the purpose of jury selection, but our goal is to set up our case in jury selection so that again, hopefully I won my case in jury selection, and certainly they've gone through jury selection, and then I step up and do my opening statement, which if I've done my jury selection, my opening statement is just repeating what we all talked about during jury selection, right? What are your expectations? What do you think the rules are in a case like this? What do you think happened in this case? Well, shoot, they already know. They know before you start your opening statement, which the beauty of it is, I'm not talking about the openings class, but it tells you how little effort, there's a lot of work behind the scenes, but how little push is required during opening statement when you've done all the heavy lifting during jury selection. And the jurors, the big mistake we make as young lawyers is we're trying to get jurors to agree with our ideas, right? This is the law in my case, and don't you agree that, would you agree that? Instead, we just ask open-ended questions during jury selection with a purpose, and they tell us what they're thinking. And it doesn't take rocket science if you ask the right question to get them to say what their beliefs are and how those beliefs are going to impact the outcome of the case. And if you're lucky, you get a little talking going and you find out how they start deliberating on your case during jury selection. Hooray, we want that.
That's awesome.
Yep. I like to say the veneer is they're auditioning for us for the job of juror. They're trying to get the job. And if they don't want the job, we don't necessarily want them on our jury.
Yeah, that's another good point. If you can tell somebody is, angry about being there, feeling inconvenienced, all that sort of thing, pay attention to that, because they still might be okay for you, but it's a red flag.
It is. Yep. No one thing would disqualify a juror for me, but the nice thing about spotters is you give them a group of jurors and they write all the notes down for the 3 or 4 or 5 people they're watching. And then you put it all together. And this last trial, the judge was, the judges are used to a lawyer doing jury selection. Then they put that do you have a strike sheet? They give you a little sheet with everybody's name on it. You draw a line through it and say, I strike this juror, right?
It was a mess this past time. It's
all online. Yours
it was like, they were like, the judge had this person, that person, they were all in the wrong squares, and they were all, so we did our own.
Yeah. But so you get that sheet in front of you right after jury selection. The defendant sits down, I pass for cause, and the clerk comes over and puts that sheet in front of me and says, who's your strike? Why don't you give me a minute?
Yeah, could I just have a minute to think about it, please?
Right. And so I just said, Judge, let's take a few minutes. Maybe the jury would like to stretch. And everybody hands me their notes, and I look them over carefully. Why have spotters taken all those notes if you aren't going to read them? And we did. We read every, all 21 jurors' notes and put stars or drew little X's over the ones we knew we wanted to get rid of. And then, because plaintiffs have to go first, we had to make that first strike. And we had a plan and a strategy for doing that. All of your hard work during jury selection, don't forget how important taking your breath and reading your notes it is not the time to do it from the hip, or my gut says get rid of this person. I should have a reason for everybody I keep and everybody I strike. And that comes from, again, we had, I was there, my associate was there, my brand new associate was there, and the director of operations for my office was there. So we had 5 people taking notes on jurors and body language, all of that stuff. Yeah.
Yeah. Yeah. And it's important to take that time. Before this last trial, the court would say, okay, you have 15 minutes to think about who you want to strike. And I always just took that for granted. And I was like, oh God, okay, now we got to, but now having tried a few more cases, and I feel more comfortable and realizing that judges half the time don't know what they're doing. And they have no idea why they're saying these things or having you do them. That if you just present it to them like, hey, juror selection is crucial and critical to my case, and my case is important to justice and our social justice, or whatever, civil justice system as a whole. I need a little bit more time. Okay, they might slap me down and say, nope, you got 15 minutes, but they might be like, oh yeah, that's a good point. I guess it's important. Let's go to lunch now and, take your time, or I'll give you whatever you need.
Just showing that you are interested, that you care, and that you consider it to be an important part of the process alerts judges to things that they just gloss over. I think if you don't say I need more time for jury selection, and anytime I get a time limit, I file a motion for more time, and I have a brief that kind of just talks about the importance of jury selection. And the judges, they go, okay, Lathrop's got his brief, but it tells the judge that I care, and it tells the judge that I'm serious about it. It isn't just me wanting to hear myself talk. This is an important part of the process of impaneling an appropriate jury. And then you back it up with a really well done and structured, entertaining jury selection, and the judge says, more people ought to do what you're doing, right? And then when you ask at the end, can I have a little more than 5 minutes or right now to do my strike? Judge, can we just take a few minutes so I can do this with some thought? Well, it seems like you've wanted to think about jury selection all the way through. That seems like a reasonable request. Yeah.
Right.
Imagine
you're not going to waste it.
Yeah. Imagine if your defense counsel in your case, who probably, I know you said it was a pretty good lawyer that you went up against, but imagine it was probably, I imagine, fairly predictable defense-like jury selection.
Kind of. I was a little bit surprised. Well, we had 2 defense lawyers because there were 2 defendants, 2 crashes, blah, 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 which was part of some of our challenge. But the one who I think I would call him a defense lawyer more than a black hat, he was super personable. It was straight up conversations. What do you like to do? Where do you like to do it? What movies do you like? Things where you knew he was kind of looking for characteristics in people. The other one was the black hat. We did have one defendant straight up black hat. I don't even remember too much. Oh, they spent the whole time pandering to the jury. I forgot about that. Yeah, the whole time. And I don't know if it worked, to be honest. I know we learned not to pander to the jury, but it was like from the bottom of our hearts, we are so thankful and all this stuff. And I was like puking in my mouth, but I was like, I don't know, maybe it's working for them because they were able to, kind of hamstring us in our case. But dude, I don't know. It was interesting. But most people, I would say most trials I've had, defense gets up there and says, if you had $84, what would you do with it? Can you be neutral and impartial? The plaintiff gets to go first, we go second. Can you reserve your judgment until after our case? Those sorts of things. Yeah,
my favorite one is I take it from your silence that you all agree with me.
Yes, right? Yes.
That's just a classic defense lawyer, and thank you for the compare and contrast, right? There's this guy over here, and then there's I take it from your silence that you all agree with me. You will all follow the law. And what happens every time defense counsel gets up after we do what we've been learned to do and learns effective, they stand up and they say, and this last jury selection, the jury they were not bothered by the amount of time I took to do jury selection. The defense lawyer will stand up and say, Well, I'm sorry. We all had to go through 2 hours of jury selection already, and I haven't even spoken, but I have some questions. I won't be nearly as
Yeah, it
long
won't
as
take
Mr.
nearly as
Lathrop,
long.
right? And if you do it well, they're going to say, well, he seems like a nice guy. Is jury selection supposed to take 2 minutes? They don't know when we stand up and do our job. Yeah.
Yeah, that was one thing about this past trial that I was a little bit taken off guard by. I was like, well, shoot, I'm supposed to be distinguishing myself right now as a different type of lawyer than the norm. And then defense gets up and does very similar to what I did. And I was like, oh man, it was very awesome.
Well, yeah, if you can create a contrast, great. But if you can't, you've at least created a comparison of yourself with people in their world, right? What they're not expecting is somebody authentic, somebody who is really just another human being. And when you're able to get that across to a jury, they don't care if the other guy is nice and also authentic. They know you are, and we can't control what the other guy's got going on. So that's a win.
Yeah, it is. It's in the way we do jury selection. It always feels good. You feel in control and all that, even if you're staring at a bunch of people who probably don't like you. But at least you've got a plan and you've got kind of a roadmap and what you're trying to get out of it because you've done the work. And we actually have a question from the audience, so I'm going to read it out. We have Kenneth Bland who says, "We're considering utilizing juror search software for upcoming trial. Any experience and/or thoughts?"
I don't have any experience. It is tantalizing to me because I'm a data guy, but we really, the way the jury, we can't, not only do we not get the information ahead of time, we get it as the jury is being seated. We aren't allowed to keep the list to even call these people afterward. They have an embargo on both ends of jury information. So I don't have any experience with it. I do know I have experience with court questionnaires. And if I could get the same information from those services that comes through on the court questionnaires, I would want to see what that does, because it really prepares me ahead of time for like one of the jurors on one of my trials she had recently moved to this community that we were in where we were trying the case. And her name came up and I don't even remember what the question was, but it reminded me. I said, "Oh, that's right. I saw in the paperwork that you did, you just moved to this town, didn't you?" "Yeah, you were in California." "Yeah." And that's not pandering. It tells you you're paying attention. I'm listening to what you're saying. You took the time to fill out that questionnaire and I took the time to read it. Thank you for doing that. Right. So I don't have any experience with them. I know that I think cost benefit, you probably have to weigh it and maybe do a dry run with a focus group, see what kind of information you get on your focus group participants, and then do a jury selection with them and see, did this help or was this a waste of money?
Yeah, I think I have no experience with that. I am not sure how that would work, but I think it would have to be something you test out ahead of time. Papa Don always says, test, don't guess. So
Right. Yep.
See if it works. And, with focus groups, you're fortunate enough to have those demographics and stuff ahead of time so you can plug whatever in to test it and see how it works.
Yep. And the data points that you get from 1 or 2 or 3 focus groups in a case with that background information is so huge, helpful. And then the other side of it is it helps you craft, or when you're doing your voir dire practice in your focus groups, you're getting practice at knowing that information, interpreting it on the fly, and finding out how is this going to affect the jury panel. And then you get to watch them, because you didn't strike them. You get to watch them through the course of your focus group act like jerks, right? So, yeah, that guy, I thought that guy was going to be a jerk, and 3 hours later, he's 100% jerk.
Yeah, absolutely. That's something that I've seen over and over and over again in my focus groups. Is I I have a judgment about somebody based on what they talked about in my little faux voir dire. They seem really great for me. At the end, yeah, they're 100% on my side, but they don't want to give any money. And then you see someone who's like, oh, they were sued. They believed it was a frivolous lawsuit. They're, angry at plaintiffs and they want to give all the money. And it's, so there's a lot to be learned through that sort of thing.
Right.
And speaking of learning, I remember from my undergraduate voir dire class, getting up on my feet and being very awkwardly embarrassed by trying this stuff out. Will you tell us, are we going to do that in this class? How is it going to be?
You're doggone right you're going to do it. You're going to do it and you're going to fail. And what we really hope in focus groups, we do 2 days of juries, mock juries. In the voir dire class, we used to do 2 days of it, and they've kind of remodeled that. And I don't know if it's because of COVID or if we're going to go back to in-person classes and just have 1 day, but we do have get on your feet with real live jurors, and you do what we taught you. And it is awkward, and it is, this isn't me, this doesn't feel right. But what we're doing is you got to get up. And I think the lesson we learned from doing it is that we need to do that with focus groups, because the material isn't going to learn itself. And where are you going to learn it? We're teaching you how to employ it when you do a focus group. So yep, get on your feet. You're going to do, I maybe only do, one little section of my jury selection with my focus group, and it doesn't make sense to the focus group. That's not why I'm doing it. I'm doing it to practice these sections so that when I'm in jury, I'm actually in front of a jury, I can say these things without reading a script or sounding like I'm trying to sound like somebody I'm not. Yeah. Yeah.
Or
So
if you word it weirdly or somehow it sounds really good in your head, and then when you say it out loud, the jury's like, huh?
yeah, or you are even worse. Yeah. Right? It comes out of your mouth, and what was that? That was terrible. Who wrote that? Yep, yeah, it was you. You wrote it. Yeah, exactly. And that's why I do 2 in-person focus groups every month, and our listserv does 1 virtual focus group every month. And for some reason, I think because I teach voir dire, they always make me do the first hour. So I am doing 3 practice voir dires a month. And I will tell you, through COVID, with all of that, no trials, 2.5 years and no trials, that first trial I did after COVID, there was no rust at all because of the practice on my voir dire and the focus groups that I had done all throughout COVID. Yeah.
All right, we're getting close to the end, but I did want to ask you when you think, I know there's kind of a list of when and how to take these colleges and that sort of thing. But if we are headed up to trial soon, or if we are mid-discovery and we can't necessarily start at point 1 and go to the end, should we take undergrad voir dire? When should we take it? And what priority should we put on that as we're kind of mid-go?
I would say as soon as you get focus groups under your belt, I would recommend jury selection, because, and that's just what I would say. I think if it's the last class you take before your trial, and your trial's in a month, and you go take the Voir Dire College, it'll help you. It'll help you a lot. But the really maximizing it is, I've had focus groups, and now I'm hungry to do focus groups. Now I've had jury selection at Voir Dire College, and I know what I want to do and practice. And when you get that focus group together and you start practicing, then you really pour jet fuel on what you learn in the college. So you can take it as late as last college before I try my big case, and it'll help.
Yeah, actually, I think when I took it, it was like right up against it was up against it, and I was still able to, even just learning the purpose, right?
Yeah.
To hell with whether I said the right words or asked the right questions. I did my very best, but at least I knew kind of what I was trying to get the jury to do, and what the outcome of that voir dire needed to be
The first trial I had after I took juries, the Voir Dire College, was a med mal case with a judge that I'd had a few years earlier. And after the first day, we were just walking out of the courtroom and he said, "Hey, I just wanted to tell you how much better your jury selection is," right? And it was just because I had purpose.
Yeah.
Yeah.
That's awesome. Well, then the proof is in the pudding, right? I mean,
Yeah, it really is.
Yeah, who knows? All right, awesome. Thank you so much, Matt. And thank you to all of you who joined us today for this week's episode of Fridays with Keenan's Cutting Edge. If you liked today's episode, please click that thumbs up and feed the YouTube algorithm. And don't forget to subscribe and sign up for alerts so you don't miss an episode. Next week, we have David Hoey back with us to speak about Trial Management College. This college is super interesting because it follows a trial that Hoey did with Papa Don in Boston, if you remember the Boston rape case. And it talks about the nuts and bolts, how to do focus groups, when to do focus groups, what to have on your desk at trial, how to compose yourself during testimony, all kinds of nuts and bolts things that we're always getting questions about. So make sure to join us next week to hear about that course and how it can help you structure your trials. I look forward to learning from Hoey next week with all of you. Have a wonderful weekend, and I'll see you next time.